Hello and welcome to the Minimum Competence episode for Monday, August 3rd, 2026. I'm your host for today, Andrew Leahy, an assistant teaching professor of law at Drexel Klein School of Law. On today's episode, Blanche rescinds the Anti-Weaponization Fund to save zone nomination. Capital One says it cut off the Trump organization over money laundering concerns. Tom Goldstein appeals his conviction, and the DOJ drops the Reflecting pool case against an ex-Olympian. Let's remember, it can't possibly be August. It was only just June. And read today's legal news. On this day in legal history, August 3rd, 1882, President Chester A. Arthur signed the Immigration Act of 1882, the first comprehensive federal law regulating immigration into the United States. Before this, immigration had been largely left to the individual states. This act marked the moment the federal government claimed the subject as its own and built the first federal machinery for controlling who could enter the country. The act did two enduring things at once. First, it imposed a head tax, 50 cents on every immigrant arriving by ship, to fund the administration of immigration, and it placed enforcement under the Secretary of the Treasury, creating the country's first federal immigration bureaucracy. Second, and more consequentially for the law that followed, it created categories of people who would be excluded. Convicts, the, quote, insane, and in language that would echo for the next century and a half, quote, any person unable to take care of himself or herself without becoming a public charge. That public charge concept, born here in 1882, is the same doctrine we discussed just a couple of weeks ago when the current administration revived an expansive version of the public charge rule. The significance of August 3rd, 1882 is that it is just the taproot of the entire federal immigration system. Coming just months after the Chinese Exclusion Act, it established the foundational premise that the national government decides the terms of admission to the United States, and it introduced the framework, head taxes, excludable categories, federal enforcement, on which everything since has been built. It's worth sitting with the tension in the date. 1882 is also almost exactly the moment Emma Lazarus was composing The New Colossus, with its welcome to the tired and the poor. The law and the poem were born together, and the distance between them, between the statute's exclusions and the sonnet's embrace, is a distance the country has been arguing about ever since. Acting Attorney General Todd Blanche has formally rescinded the $1.8 billion Anti-Weaponization Fund, clearing what had been the biggest obstacle to his confirmation. If you were with us last week, this is a resolution of that story. The fund, created by a Justice Department order back in May, would have used taxpayer money to compensate people who claimed to be victims of the prior administration's Justice Department, a group that notably included those convicted in connection with the January 6th Capitol attack. Republican Senator John Cornyn had refused to support Blanche's nomination until the fund was killed. And this week, Blanche did exactly that, signing an order declaring the May directive rescinded with no force or effect, and as part of the deal, agreeing to limit the related immunity arrangement so it applies only to the IRS and not to other agencies. The significance ties together several threads we followed all summer. This fund grew out of the same collusive IRS settlement that a federal judge voided as a sham, and it sat at the center of concerns about the Justice Department being used to reward the president's allies. That a senator from the president's own party forced its formal repeal as the price of confirmation is advice and consent, working as a genuine check. And it means the incoming attorney general takes office having had to publicly dismantle one of the administration's most criticized initiatives before the Senate would trust him with the job. If you're wondering what would stop him from simply reviving it after he has been confirmed, the answer to that is absolutely nothing. In a court filing, Capital One has disclosed for the first time that it closed more than 300 Trump Organization bank accounts back in 2021 after an anti-money laundering review, the first time a bank has formally tied such concerns to its decision to cut off the president's family business. The context is a lawsuit. The Donald J. Trump Revocable Trust and Eric Trump sued Capital One in Florida last year, alleging the bank debanked them for political reasons, having notified the Trump Organization of the closures in March of 2021, just weeks after January 6th. Capital One's filing reframes that story entirely. The bank says its compliance team did precisely what federal regulators expect, flagging accounts that raised anti-money laundering red flags and acting on them. Here's the legal machinery underneath. Under the Bank Secrecy Act and related anti-money laundering rules, banks are legally obligated to monitor their customers, file suspicious activity reports, and, when warranted, to close accounts. Failing to do so can expose a bank to serious regulatory penalties. Importantly, Capital One did not accuse the Trump Organization of actual money laundering. Flagging a risk and proving a crime are very different things. The significance is that this is a clean collision between two hot legal debates: the debanking complaint that financial institutions are dropping customers for political or ideological reasons, and the reality that banks operate under mandatory anti-money laundering obligations that require them to shed risky accounts. A court will now have to decide which of those framings fits what Capital One actually did. Tom Goldstein, the prominent Supreme Court advocate and SCOTUS blog founder we've been following, has launched his appeal. asking the Fourth Circuit to overturn his 12 convictions for tax and mortgage fraud and to undo his 6-year prison sentence. Let's recall the case. A jury found that Goldstein concealed millions from a secret high-stakes poker life, diverted his law firm's fees to cover gambling debts, and lied to mortgage lenders. He was sentenced to 72 months in order to pay more than $3 million in restitution. The appeal is a reminder that even a resource-intensive headline conviction gets a second look, and Goldstein is raising some genuinely lawyerly arguments. The most interesting is venue, the constitutional requirement that a defendant be tried in the right place. His team argues that while prosecutors proved he filled out loan applications in Maryland, they never proved from where he actually transmitted the documents, leaning on a recent Fourth Circuit decision that took venue seriously. He's also challenging the admission of statements he made in media interviews and the wording of the jury instructions. Commentators describe his path as daunting, and it is. Appellate courts rarely overturn convictions, and factual findings get real deference. But the significance is that these are exactly the kinds of technical, procedural issues on which serious appeals are built. Goldstein spent his career winning cases at the top of the appellate system. Now he's testing whether that same system will scrutinize the government's work in convicting him. And finally, the Justice Department has moved to drop its criminal case against David Hearn, the former Olympic canoeist charged with vandalizing the Lincoln Memorial reflecting pool, and the reason is striking. We covered Hearn's not guilty plea back in July when his lawyers called the prosecution an abuse of power built on a concocted narrative. Turns out the characterization was closer to the truth than the charge. In a 20-page filing, prosecutors acknowledged that evidence received after Hearn was indicted shows the damage to the pool, quote, was the result of flawed installation by the contractor, compounded by the rush to complete the project before the America 250 celebrations around July 4th. In other words, it wasn't vandalism, it was shoddy construction. The U.S. Attorney's Office said it only learned of the flawed installation evidence after a grand jury had already indicted him. The significance goes right to prosecutorial power and its risks. A 67-year-old man was detained for hours and charged with a felony over damage that, by the government's own admission now, he didn't cause. The case collapsing is the system correcting itself, but only after Hearn spent weeks as a felony defendant and presumably spent quite a bit of money as well. It's a real-world illustration of a point we keep returning to. The decision to charge is one of the most consequential and least reviewable powers in the legal system. And when it's exercised on a flawed factual premise, the damage to the person charged is done long before the dismissal. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow. And until then, remember, the prosecutor has more control over life, liberty, and reputation than any one person in America.